Ladies and gentlemen, I have an announcement to make in respect of a amendment to the State Lands Decree. In fact, the State Lands Amendment Decree is an amendment to the State Lands Act, which was in fact put before Cabinet before the Honourable Prime Minister left for France. The proposal by the Prime Minister had been approved by Cabinet and has now been gazetted. What essentially this does, and you'll be getting a written statement on this, which will make things easier for you, is that previously the law was that you can have, for example, and as the law is still there, you have state land that is owned by the state, which can be converted to freehold if you did a land swap. So if somebody, for example, wanted some state land, if say it was 10 acres, they could come along and needed to go through the proper approval channels and get, if they offered you 10 acres of freehold land somewhere else, they could swap it. It was called a land swap. Now, of course, we changed the law last year where apart from the land swap, they have to also pay you compensation. So you could convert state to freehold. You could not convert I-Taukei land to freehold. That was prohibited. However, what we saw happen under previous governments, and at the moment we're carrying out some investigations, that what has happened where you could, however, convert I-Taukei to state. You could convert I-Taukei to state, but you could not convert I-Taukei to freehold. But what happened under the previous governments, they would convert I-Taukei to state and then convert that state to freehold. So that was one way of bypassing the system. So the proposal by the Prime Minister, which has been approved by Cabinet and has been gazetted, now prohibits any I-Taukei land from being converted to state land and then to freehold. So in other words, if any I-Taukei land is converted to state land, that land is ring-fenced and it cannot ever be converted to freehold. If the state does not require it or wants to give up ownership of it, it goes back to I-Taukei land. Now what is very interesting is that despite having entrenched provisions, as some of you would know, in the previous constitutions, where you could not, for example, change any even a sentence to laws such as NALTA, etc., because they were entrenched and you needed certain veto powers. Despite those supposed protections being in place, all these other practical things were happening, where land was being alienated. So what this does now, it demonstrates to us that it's not a question of the laws being entrenched, it's a question of ensuring that the law has a practical and effective mechanism for the protection of rights, including any property rights. So this again is another feature of the Bainimarama government's position and its interest to continue to protect the land ownership of the I-Taukei landowners.